What do you need to know about the quirky terms of separation agreements in an ERISA disability claim? Now, I've touched on this before, but I want you to think about what's happening in today's environment. There was just a recent article about how discrimination claims are increasing because employers are asking employees to go back to work as the post-COVID era ends. And many people who have been able to work from home, notwithstanding their disability, and potentially collect long-term disability benefits. Or conversely, they have been able to hide their symptoms, and now they're being faced with the choice of either having to terminate their employment or going back to work, and they really don't want to go back to work because of their disabling symptoms. So what's happening, as this article is pointing out, is we've got on the one hand employment discrimination claims being brought in as part of any settlement of these particular issues. You're being asked to sign a separation agreement as part of the resolution of this lawsuit. Now, I'm not an employment lawyer. I am an ERISA disability lawyer. But I want you to understand that if you are asked to sign one of these, that there's potentially a problem, because in these releases they will generally ask you to release any claim that you might have for ERISA disability benefits, short and long-term disability benefits, pension benefits, group insurance benefits. That can be problematic for several reasons. One is if you sign it, you're giving up your rights and you can't file a claim. Courts are going to uphold these releases. Secondly, if you have been working at home and have been disabled but haven't let your employer know, and now you want to file a claim, there's some work that needs to be done. And that's important because many disability policies will have what's called an elimination period, which means that you have to be disabled for a period of time before you can actually collect your benefits. And the length of that time varies from policy to policy. If you are going to be signing a release, terminating your employment, and getting a check, if you will, for the separation agreement, and then you want to file a claim for disability benefits, the carrier might say, look, you worked until you got involved in this litigation. You were able to earn money. You weren't losing the requisite wages. No doctor said you were disabled, and we're going to deny the claim. So if you're faced with this prospect, I think what you need to be doing is consulting with an employment lawyer and consulting with an ERISA disability lawyer such as myself. So there can be some real good planning. Planning to deal with the terms of the separation and the release, planning to make sure that you have a physician say that you're disabled and unable to work, and potentially, retroactively, and the attorney's going to be looking at the policy to see whether or not you had to have a requisite loss of income before you can claim that you may have been working while you were disabled. So this can all impact ultimately an ERISA disability claim. Don't make a mistake. That can just destroy the ERISA disability claim. Call us today at 727-894-3188 for a complimentary consultation.